that is serial 15.
Yes.
The pleadings are complete, and I have informed, though they have not consented, but yesterday night I informed Mr. K.K. Singhal, at State Council. If not today, then any other sorted date is fixed. This relates to the petitioners. They were given out of turn promotion because of winning gallantry award, and now that promotion is being undone because the seniority list has been fixed from the basic cadre of constable and not from the date when they have been given the said
You
promotion.
have filed your synopsis.
Synopsis is that we have prepared, that we have not filed because the matter was
You
not
file
taken.
it. You see, you know that these kind of matters I do not take up without the proper synopsis and list of dates. You file it.
I would be only praying if it is.
It can't be like this. You file it first and then make us mention. So the next question.
From supplementary list for admission item 1 WPS 6941 of 2023.
In this case, probably counter has been served to some other person.
Some other person.
Counter was filed earlier, there are probably Bharat Kumar, there are two advocates.
Other Bharat Kumar.
Today we have come to know that he has not been served.
You see, the situation is that there is an interim order,
Yes, well, that-
right?
Lordship will keep it after 2 weeks.
After 2 weeks, you want this matter to become in practice.
See,
Yes, please hold on.
Today it's a not real.
You see, they have stated that there is a 10th examination
Yes, ma'am.
of the child. The last exam is on 13th of March 2020.
Yes, ma'am.
So he has already enjoyed the leave which he wanted.
Yes, ma'am.
Almost, right? So you don't disturb him till 13th of March, and you have already stated in your counter affidavit that that he was asked to file some application. Did he file
That
that?
has been rejected.
That
Has been rejected?
Yes, that
They
is
have
the
mentioned it. The competent authority, even in the ministry, the application was sent, that has been rejected. This is can you accept E, Ministry of Home Affairs, page 33 of the counter of document. Competent authority has directed to relieve Dr. Shabana Mehnaz from CHCRPF Ranchi to ITBP immediately.
So she will not be entitled for
That is
child
right.
care leave.
That is the right.
That is, she will be given so far as that benefit is concerned when she will join their itself. That is the affidavit which has
Yes,
been
yes,
given.
we appreciate that. That is
So far
that.
as the total period that has been mentioned, she is entitled for 720 days so far as the entire career is concerned. And during that period, immediately after joining, she will make an application and accordingly she will be allowed.
It can be given post facto also.
Yes, that is the stand which has been taken in the affidavit.
Okay. Then under such circumstances, we can ask her to join our post her last examination, his last examination. See, it's almost over.
Yes, Lord, I am not saying so far as the stand which has been taken in the
Sorry?
affidavit.
Next week, Your Lordship, I will take.
What instructions? You have yourself stated that the last exam is on
Yeah.
13th of March. So you join on 14th of March. Simple. What's the big deal about it? Your crisis will be over. Child care leave, that crisis will be done, taken care of. That much should suffice. And then after joining, you file your application. They will take care of whatever your entitlement is. There is already an interim order in your favor.
Paragraph 16, we have mentioned about the child care leave.
Yes.
It is very much clear that she has never been denied for CCL and she was directed to apply for CCL from her parent organization after reporting ITBP headquarters.
Yes.
This is Annexer
So post
G.
facto it can be done, Mr.
Yes, this is Annexer G. Kindly see,
No, because it is one thing to say that you apply and then you get. It is another thing to say that even if you are absent, you can get it post facto also. Because she has not joined.
That I have not examined so far as that issue is concerned. Because Annexer G says,
When did you apply for child care leave?
I have applied in initial 6 Your Lordship, page 16/10/2023.
1610?
2023, page 25 Your Lordship. Annexer 6.
Page 20.
25.
We can do one thing. Since he has not been served with a copy of the counter affidavit,
Yes, ma'am.
we can adjourn this case and post on maybe 11th March. In the meantime, we will file his rejoinder. On the next day, we will say that this case has become infamous. We go and join and apply. That will serve the purpose.
So,
At times, adjournment also serves the purpose.
yeah, it's
But other grounds are absolutely meaningless.
yeah. Therefore, I had confined my prayer.
IFB or whatever.
I,
IVF.
IVF.
I had confined my prayer to this only. Your Lordship.
The learned counsel for the parties address it. The counsel for the petitioner submits that although a counter affidavit has been filed in the present case, but the same has not been served upon him. The learned counsel for the respondents undertake to serve a copy of the counter affidavit to the counsel for the petitioner by day after tomorrow.
By tomorrow.
By tomorrow. Rejoinder, if any, by 29th February. Pose this case on 11th March under the heading for final dismissal. And you also figure out if there can be any post-facto approval of.
I'll examine, my lord. I was
Consider it simplistically.
the
Class
affidavit
10th
where I was going
examination are
was-
so crucial for the children now.
Yes, my lord, it becomes, my lord. I am not denying, my lord. The only thing, my lord, so far as the authority concerned, my lord, they have stated you join and get an application. That will be
That
approved.
is why-
It will not be denied, my lord.
That is by 226.
Yes, ma'am.
That's right.
Item from daily list for final soul, item 1, WPS 1979 of 2023.
Prayer, simple prayer made in this petition is that the respondent may be directed to consider the case of the prisoner for his appointment as member of district Convening Forum in any vacant post in any district of Jharkhand.
Has your prayer been rejected?
No.
What is
Earlier,
your entitlement?
He filed a writ petition challenging the entire selection process.
Okay.
So kindly see the writ petition, annexure 6, at page 53. So he has challenged the entire selection process, but finally that writ petition was dismissed with giving liberty to the petitioner to not pray for appointment.
Where is that liberty?
But,
So,
Annexure 6.
so the entire screening committee was under challenge. Constitution of screening committee.
So that has been.
Where is that liberty? Let us read that liberty.
This liberty is explainable to page
Para 12.
50. Paragraph. So far as the case of the prisoner concerned, he has not been selected. Rather, the case of has not been placed before the selection committee. In this petition, the only thrust is upon the process. Since the process is in accordance with the law and the rules, I find no ground to accept the conclusion of the evidence so far as the petition is concerned. If the petitioner feels that committing illegality or renewing his qualification, his case was not considered, it will be open to the petitioner to file a separate petition restricting his case on the
So your candidature was not considered.
No, it was not even placed before the selection committee. What happened?
But
In the
now
midst of
the
proceeding,
now the selection is over.
selection is
All the vacant posts are filled up.
No, there are some posts are still lying vacant. As per my information, 4 posts
But
are
every
lying
time
vacant.
the selection process is, you see, now pursuant to the selection process which was under challenge in the earlier writ petition, all the vacancies were filled up or they were not filled. Subsequent vacancy will not
The
serve
state-
your purpose.
No, I am praying for fresh consideration for his appointment.
So
Since he is
fresh consideration will be done only when there is a fresh advertisement. Why your isolated case can be considered on the basis of an application which you had filed earlier?
in view of the liberty given
That
to the
liberty,
petitioner.
then you show us that there is some illegality in their process.
That is, there is my lord. Therefore, he had challenged the entire selection process. Now, court was the
Where is the
honorable court
advertisement?
was
Where is the advertisement?
of the view.
Where is the advertisement? And how many posts were advertised? And for which post did you apply?
For the post of member.
Member
of
in which
district?
district?
District Consumer Forum.
Which district?
He has prayed, that's my prayer 2 made in the writ petition. He prayed for issuance of an appropriate writ, especially a writ in the nature of mandamus, commanding upon the respondent authority to address the petitioner in the vacancies of the post of member going to be available in district Consumer Forum, Rachi, Pakur, Chapra.
Going to be
Palamu, and
available, it can't be adjusted like that. There has to be a fresh advertisement.
what happens?
Your name cannot be adjusted against future vacancies.
No, existing vacancy.
Even
For the reason,
no,
what happens?
you are not getting it. If 10 posts are advertised, if out of the same very 10 posts, if there is vacancy and not filled in connection with one or the other post,
And
your
if-
case can be considered. But if initially the 10 post is already filled and subsequently there is a vacancy because of retirement or whatever reason, then under such circumstances, how your case can be considered against future vacancies?
So, in
Or
that,
subsequent
in that
vacancies.
juncture, the state is the
The new vacancies
best person to
should
say.
come then only,
Yes.
because in the vacancy, once out of merit only, we have seen that how many will be fulfilled or not. And first of all, first prayer is for wrongly not considered, and second prayer is to adjust the petitioner. Both the prayers are contradictory in itself, Your Ladyship.
That is the fact. His candidature was not considered.
Question
Where
Since
have
to
you
the selection
stated?
committee.
Let us see
Screening-
that by your name. Where have you stated that your name you applied? Where is your application?
Oh, अच्छा,
Let us see.
Answer 2.
You place it from the writ
Answer 2
petition.
series.
You place it from the writ petition.
Answer 2 series.
You place it from the writ petition, not from
Yes,
the
yes.
annexures.
Annexure 2 starts at page 33. That is the prescribed form which was filled up.
You applied for the district of Dhanbad, Bokaro, and Ranchi.
Ah,
Okay. All right. Then what happened?
after his other
Para 18.
credentials.
You come to para 18.
Credentials have been
Come to para 18.
academically I've stated. Para 18, yes. So, it is submitted that the petitioner come to know that the selection process is completed, but however, the name of the petitioner was not selected or recommended by the selection committee. Therefore, the petitioner represented before the respondents that his name should have been selected for the reason of his excellent service record. But however, no response was given by the respondents. So he filed a repentation. And answer
See,
3 is the repentation. Kindly see.
You were not. The selection process was over. and thereafter you challenge the selection committee.
And vertical you have looked to the annexure 3, that is the representation file of the petitioner.
Representation
44.
will not serve any purpose.
Page 44.
Representation will not serve any purpose. You were not called for interview. At least interview must be there.
Selection process has a due
No, no.
process for the appointment.
You simply say that you applied and you found that people have been selected. You do not say that you were called for interview or you did not go because the selection committee was illegally constituted. That is not the
His
case.
grievance is that a screening committee was constituted as per the rule of
That challenge has
2020.
been negated by the earlier writ court.
therefore petitioner was given liberty to apply file an application for consideration of the by the respondents, and hence this writ petition has been filed only in view of the observations given by this honorable court in his earlier writ petition, and he is fulfilling all the eligibility criteria, and
was
also
awarded lesser marks.
the persons having less credential have been selected and appointed. The petitioner was by that time he was practicing for 37 years, and he was standing counsel for the central government and also labor department, railway council. So all criteria he has fulfilled.
So,
And-
being a counsel for central government, being a counsel for railways, is
These
a
are the-
certificate of your merit?
These are the credentials for being appointed,
That's right.
and
Show us that he got less marks.
Yes, Your Ladyship. As per the documents and records, in page 76 of the writ, Your Ladyship,
Para number 20.
yes, Your Ladyship. And in the page 76 annexure, there we can see, Your Ladyship, 47, how much marks he has secured.
39.10.
39.10 marks out of places,
That's right. He got lesser marks.
lesser marks.
That's it.
so in case the case of the petitioner was never placed.
It was placed. You got lesser marks.
No, it was what happened. There is no system of interview or either
We do
written
not know.
or
Selection process
but
is
yes.
now
not under challenge.
Cutoff marks was, Your Ladyship, 49.80, and for waitlisted candidate was 40.
that is what they are
And
saying,
pe-
that
pe-
his case stands at serial number 47. But when his case was not placed before the selection committee, then how the
You just
result?
tell us, as per the advertisement, after you file your application, were you supposed to be called for interview?
No, there was no written test, no interview.
No, so
Only on the basis of the credentials,
that's
which
right.
are supplied by the candidates.
Okay.
So
That's it.
in that case, the petitioner,
The
as well
advertisement
as
is not under challenge,
And
isn't it?
my lord,
The advertisement is not under challenge.
no, he challenged. He had not challenged. He had
It is
challenged
not
the
been
selection
challenged
process.
because he himself wanted to
In
adjust
earlier
in
petition,
the
he had
present
challenged the selection
vacant
process.
post, Your Ladyship.
Very
And now, in view of the observation, he simply prayed that his case may be considered in the existing vacancies,
We will.
since he is fulfilling all the eligibility criteria.
देखिए, WPS number 1979 of 2023. The
Your
Learned
Ladyship,
Counsel for
these are
the
two judgments.
parties are
Placing for
present.
the rules.
This writ petition has been filed for the following relief. The Learned Counsel for the petitioner has submitted that the petitioner
Yeah, I may.
has been a practicing advocate at Civil Court, Dhanbad, and have excellent credentials whose detail has been mentioned in paragraph 8 of the writ petition, and adequate experience. He submits that pursuant to the rules, namely consumer protection within bracket qualification for appointment, comma method of recruitment, comma procedure of appointment, comma term of service, comma resignation and removal of president and members of state commission and district commission, bracket close, rules 2020, page 9 में. The petitioner had applied for his appointment as a member of District Consumer Forum in terms of advertisement number 4 of 2021. The petitioner had applied for the district of Dhanbad, Bokaro and Ranchi in preference, and other details were also provided in his application. Suddenly, the petitioner came to know that the selection process was complete and the petitioner was not selected or recommended by the selection committee. In spite of his excellent service record, the petitioner was not selected. The petitioner had filed a writ petition before this court earlier in WPS number 248 of 2022 as contained in Annexure 6. The same was WPS number 248 of 2022, wherein the petitioner had challenged the selection process for appointment of members of District Consumer Commission pursuant to the advertisement number 4 of 2021. He had also challenged the procedure by which the application were first placed before the scrutiny committee before placing the same before the selection committee. The said writ petition was dismissed by the order dated 22/2/2023. However, a liberty was reserved with the petitioner to file a separate writ petition if the petitioner feels that committing illegality or ignoring his qualification, his case was not considered. Consequently, the present writ petition has been filed. The grievance of the petitioner, as mentioned in the writ petition in paragraph 24, is that the petitioner was eligible but his name was not placed before the selection committee for consideration on merit. The learned counsel submits that since the candidature of the petitioner was never considered on merits, therefore the present writ petition is fit to be allowed, and the respondents be directed to adjust the petitioner in the vacancies of the post of member going to be available in the District Consumer Forum, Ranchi, Pakur, Chatra, Palamu and Ganga.
What happens in this connection, I want to submit that after age limit is 65 years. So on
Yes.
expiry of age,
I would.
vacancies.
The Learned Counsel for the respondents, on the other hand, has opposed the prayer of the petitioner and has submitted that, as per the counter affidavit, the matter was placed before the selection committee and the cutoff marks for selected candidate was 49.80 and for waitlist candidate it was 40. The petitioner got only 39.10 marks and ranked 47, and therefore his name was out of the selected candidate as well as waitlist candidate. It has been submitted that the name of the petitioner cannot be adjusted for vacant post of members in the district commission. The Learned Counsel submits that the petitioner cannot have any right to seek appointment against future vacancies, and if the future vacancies are to be filled up, the same will be filled up by issuing fresh advertisement. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that petitioner was one of the applicant pursuant to the advertisement issued under the aforesaid rules, being advertisement number 4 of 2021. The petitioner had applied for the district of Dhanbad, Bokaro and Ranchi in preference, and when the petitioner was not selected, and as soon as he came to know that the selection process was complete, the petitioner filed a writ petition being WPS number 248 of 2022, challenging the selection process and also the procedure by which the applications were first placed before the scrutiny committee before placing the same before the selection committee. This is reflecting from the paragraph number 2 of the judgment passed in WPS number 248 of 2022, which is quoted as under. This court, after considering the case of the parties, rejected the challenge of the petitioner with regards to constitution of the selection committee and the procedure adopted by the respondents in the matter of selection. Paragraph 10 and 11 of the judgment passed by this court is quoted as under. However, some observation was made in connection with the claim of the petitioner, with the case of the petitioner at paragraph 12, which is also quoted as under. Thereafter, the present writ petition has been filed by the petitioner for the relief as quoted above. The petitioner had taken a plea in paragraph number 24 of the writ petition that his case was never placed before the selection committee for consideration on merit. This plea of the petitioner stands negated by the respondents through the counter affidavit, wherein it has been mentioned that The cutoff marks of the last selected candidate was 49.80 and for waitlist candidate it was 40 and the petitioner had secured only 39.10 marks and ranked 47th. Thus, this court finds that the case of the petitioner was placed before the selection committee and appropriate marks was allotted and ultimately the petitioner was not selected. The petitioner having not selected on merit the relief as prayed for by the petitioner in para 1 within bracket 1 cannot be granted. So far as the prayer made in para 1 within bracket Roman 2 is concerned, no such relief can be granted in view of the fact that the petitioner's name did not even figure in the wait list and the petitioner is seeking his adjustment against future vacancies of the post of member which is going to be available in the District Consumer Forum of Ranchi, Pakur, Chatra, Palamu and Garhwa. This court is of the considered view that no such relief can be granted to the petitioner against future vacancies. The future vacancies are to be filled up in terms of the rules and no candidate can claim any adjustment against future vacancies. Accordingly, this writ petition is hereby dismissed.
Permission item to WPS 899 of 2023.
That question. So with the last decision that the record of the earlier application was just was called for. Today the facts of the case is that in lacking of the proper instruction of the petitioner in earlier application, the direction was sought for his appointment on the post of non-para teacher against the vacancy board annexure 1, which is contained in annexure 1, that was numbered as 1/2015, instead of the advertisement number 6 of 2015. That I have also annexed the copy. Now, since
No, you applied under which advertisement?
it was first I had applied against the advertisement number 1/2015. That was still cancelled.
This was for para teacher.
Non-para teacher.
Sorry?
Non-para teacher.
No, it was para teacher for all the para teachers.
There are two categories. Paras
In the
and
same advertisement, there were two categories.
two categories. But I had applied for the non-para teacher.
Okay, that's right. So you applied there under.
Yes.
Okay.
And followed
You applied under non-para category.
non-para teacher. Against the advertisement number 1 of the 2015.
Okay, you were para teacher or non-para teacher?
Non-para teacher. I get in.
You were non-para teacher, applied under non-para teacher.
Non-para
capacity.
teacher.
Okay, then?
Then followed that advertisement was followed. It had applied thereafter. Followed just after 2 months or 1 month. That is in terms of the order passed by the secretary of the department. That all the procedures, my lord, that was already started, that was stood cancelled, and thereafter the fresh advertisement was, my lord, advertised. That is that is advertisement number 6 of 2015.
This is fresh advertisement.
Fresh advertisement.
And,
All
they,
the
and nobody was selected pursuant to the law.
nobody selected in the first advertisement. No counselling was ever made.
Okay, then?
Thereafter, my lord, that I applied.
You were supposed to apply afresh?
fresh,
Okay. Then you applied under
I
which
applied.
category?
and thereafter the counselling started.
You again applied under non-para category?
Non-para teacher
Okay.
against advertisement number 6 of 2015.
For which district?
My lord,
For which district?
District Sahibganj.
District Sahibganj. Then what happened?
Thereafter, my lord, that the counseling started.
Okay.
I was selected in the fifth counseling. I had given the chart, and I secured, my lord, 63.37 marks in the counseling.
Okay.
But by discriminating the case of the petitioner, my lord, to the candidates securing lesser marks were selected.
Who was the candidate who got lesser marks?
So that I have shown that I have given the name.
In your district?
EN district, same district, Sahibganj.
Okay. Where is that?
That's the annexure. The detailed charts I have filed, but the details chart I have shown that.
Where is that?
Through a supplementary affidavit. At page 16 of the supplementary affidavit.
Yes.
Lord, my name stands at serial number 31.
31.
31. Page 16 of supplementary affidavit.
Umesh Chandra Mandal.
Lord, it starts for Ranjit Kumar Roy. I am the Ranjit Kumar Roy.
Ranjit Kumar. 31 is not Ranjit Kumar.
It starts from the serial number 28. Chota sa likha.
No, 28 is Jai Narayan Prasad.
Yes, Jitendra Kumar.
No. 31 is, what is your, where is your name? Your name
My
is
name
at,
is 31, Ranjit Kumar Roy.
no, I don't find that name.
Umesh Kumar Chandra Mandal.
In your supplementary affidavit.
Supplementary affidavit. I am saying about supplementary affidavit. And 16 of the supplementary affidavit. Page 16 of the supplementary.
31. Ranjit Kumar.
Ranjit Kumar Roy. And the candidates securing lesser marks,
Yes.
that is at
Where is your marks given?
that is the second column, remarks, and there are before that remarks that total marks obtained. The remarks just behind the remarks column
63.38.
38
37.
37,
Okay.
and the person who are
Who has
securing
been
lesser
selected?
marks.
Yes. Who is that person who is lesser marks and has been
Kishan
selected?
Chandra Mandal,
Where is
Mahavir
that?
Yadav.
They must be under reserve category.
I was also reserve category. I was belonging to BC community.
BC. Okay. Then where are those persons? Where is their name?
Mr.
Serial number? Serial number?
Serial number 34, 32, 35, 38. And so many persons followed. I followed that side, could not identify them. But there are so many persons. But some of them that I know them, they have been selected.
You were never offered the appointment.
No. That is my case. But what they said, my lord, in the meantime, what happened that, just my lord, in the after coming of
So the selected candidates who had got less marks than you were at serial number 32, 34, 35 and
30, 35
and
and
30.
36. Last one. C.R.
36,
Prasad,
39 and 39 also.
39.
36 and 39. Yes. What have they said in the counter?
They stated in the counter affidavit was filed, my lord, just that was after, my lord, the filing of the REIT application pursuant to the advertisement number 1 of 2015. Though it could be rectified, but subsequently it was detected that the council has done mistake, and subsequently amendment petition was filed for the relief by annexing the copy of the advertisement number 6 of 2015. But the prayer of the amendment could not be allowed, and the liberty was given to file a fresh writ application since the cause of action is fresh, that is 6 of 2015 is advertisement against which I had applied, and all the
No,
procedures.
what is there in the counter affidavit? You
Yeah.
have filed the supplementary after the counter affidavit.
Yes.
Why? Why didn't you file it earlier?
No,
They would have responded
they
to
have
it.
They have filed the counter affidavit in earlier writ application, and in that application, in the counter affidavit, they have stated that I was found overage,
So,
but it was not the fact. I was, my lord, within the, my lord, the cut-off age which was determined by the respondents as per the recruitment rules. My lord, I am reading that. The counter affidavit. It should be filed. They have not stated below about the the advertisement number 1 of 2015.
no, you just tell us where is the counter affidavit in this case? No counter affidavit
No,
has come.
but it was called for below that just on the last date. For that purpose.
For the query.
Paragraph 11 of the counter affidavit. Why I could not be, my lord, appointed, that was the reason given in that counter affidavit. It was updated about 23rd January 2018.
You applied under general category.
No, that was not or maybe one of the court will be, my lord, it may be that they can produce the
Have you
application.
stated that you applied under reserve
BC.
category? Under BC category?
BC category.
Where is your statement in the repetition? Let
Yes.
us find it out. That you had applied under BC
Yes.
category.
Paragraph 18. At 18, my lord. Paragraph 7.
In the earlier repetition, a counter affidavit was filed.
Yes. and all the amendments made in the counter affidavit relates to the advertisement number 6 of 2015. No, since the advertisement number 1 of 2015 has lost its existence after my lord the order of the secretary.
You see, after ninth counselling,
Yes, ninth counselling, my lord, that it was
last cut-off marks for appointment of elementary school teachers in merit list was 65.80 in BC category.
yes. But till then, my lord,
Whereas you had got only 63.36.
I could not, my lord, I could not participate because I was, my lord, just my lord, I was restrained from my lord availing the other counselling. They could not
So-
select, and they have been
No,
declared.
I am not able to get it. In the last counter affidavit which you are referring to, you got lesser marks than the last selected candidate in the BC category.
But the persons, my lord, have been selected who have found, my lord, lesser marks in the fifth counselling. My marks is, my lord, 63.37 marks in the fifth counselling. I could not be selected.
So those persons whom you say were selected, they were selected in the same counselling.
Same counselling. And they have, my lord, given the name of the other persons who were selected in the ninth counselling. I have no concern with the ninth counselling.
What was the cut-off date? What was your age as on 1/8/2015?
42 years. That is, I do admit.
So you were within the age.
No. I was overaged as per the advertisement number 1 of 2000, which has lost its existence. But as per the advertisement number 6 of 2015, the age relaxation was given for 7 years. That means, my lord, I was eligible till 44 years.
देखिए, the learned counsel for the parties are pressed. The learned counsel for the petitioner has submitted that initially an advertisement number 1 of 2015 was issued for appointment of para teachers, and the petitioner had applied. The petitioner, being a non-para teacher, had applied under non-para teacher category. However, no counselling was done pursuant to the advertisement number 1 of 2015. Fresh advertisement was issued, being advertisement number 6 of 2015, wherein relaxation of 7 years was granted to the backward class category. The petitioner was overage so far as the advertisement number 1 of 2015 is concerned, but on account of the relaxation given in the advertisement number 6 of 2015, the petitioner was duly eligible for consideration. He further submits that the petitioner had applied for the district of Sahibganj, and in the fifth counselling, the marks shown with respect to the petitioner was 63.37 marks. He submits that that many candidates and the name of the petitioner was at serial number 31. The list has been filed along with the supplementary affidavit in the present case. The learned counsel submits that many candidates, including those at serial number 32, 34, 35, 36 and 39, who had participated in the fifth counselling, had got less marks than the petitioner and were selected. The learned counsel has submitted that in such circumstances, the petitioner was aggrieved and had filed a writ petition earlier, being WPS number 5109 of 2017, but the same was ultimately withdrawn by the order dated 22/11/2022. on the ground that the advertisement against which the petitioner was seeking appointment was withdrawn. Why did you withdraw this writ petition?
Because, my lord, the coordinate bench review, my lord, that is, I have challenged I have come against the advertisement number 6 of 2015. So the facts will, the pleadings will be changed. So on that view, my lord, that.
No, but you have withdrawn it. How can now the relief be granted to you?
But it was with your liberty, my lord, that to file a fresh application, and this will not come in the way of the petitioner for filing fresh writ, taking all the grounds, including the grounds as sought for in the interrogatory.
The learned counsel submits that the liberty was reserved with the petitioner to file a fresh writ petition on fresh cause of action. What is a fresh cause of action?
This cause of action, or that the averments made the counter affidavit is not applicable in my case,
No, that is not the fresh cause of action.
and I've been also been debarred from what being selected.
And therefore the petitioner has filed a fresh writ petition. Upon a query of this court, the learned counsel for the petitioner has submitted that a counter affidavit was filed in the earlier writ petition, being WPS number 5109 of 2017, wherein the reason for not selecting the petitioner was shown to be overage is a fresh cause of action for filing the present writ petition. Counsel for the respondents, on the other hand, has opposed. Are you supporting, opposing?
My lords, as per the instruction, my lords, his case will be considered. My lords.
His case will be
Considered.
as per your instructions.
Yes, my lords. But I have taken instruction from the department.
The learned counsel for the respondents has, although this court is not considering the aforesaid facts and circumstances, this court is of the view that the counter affidavit filed in the earlier writ petition cannot be said to be a fresh cause of action. However, the counsel for the state has submitted that the case of the petitioner will be considered. As per his instructions, the respondents are ready to consider the case of the petitioner
Yes, my lords. For the counseling, my lords.
for counsel.
Fresh counsel.
For fresh counsel.
Yes.
You file a counter affidavit. Who will file the counter affidavit?
Lords,
Who will file the counter affidavit?
the DSC.
DSC is nobody. Respondent number 2 should file the counter affidavit. Let a counter affidavit to this effect be filed by respondent number 2. By next week.
2 weeks.
We can't give you more time because there are division bench orders that there will be only one counselor. We can't give you more time. If you are ready, you have received instructions, you file your counter affidavit. Then your case will become infructuous. If such a counter affidavit as submitted by the petitioner in the line as submitted by the petitioner is filed, then essentially this case would become infructuous.
If they are ready to consider, what remains?
Post this case on next Wednesday. Let the counter affidavit be filed of the director of the respondent number
Respondent 2.
to be filed by next Wednesday.
21st it will be.
Sorry, I don't know what would be the date.
28.
On 28th. You file it by Wednesday.
Item 3, WPS 1361 of 2023.
On 12th of February, we have received supplementary counter.
WPS number 1361 of 2023. Counsel for the petitioner prays for and is granted time till 27 February to file rejoinder to the supplementary counter affidavit. Post this case under the heading for final disposal on 5th of March. Counsels to Parties to prepare list of dates and synopsis of argument and also file judgments which is to rely upon.
Item 4, WPS 2133 of 2023.
Yes, petitioner.
My Lordship, learned counsel drafted and just coming. Pass on, please.
Who is for the respondents? WPS number 2133 of 23.
CKM, my Lordship.
The pleadings are complete? Or you want to file a rejoinder? You don't want to, no rejoinder is required? Think over it. I will not grant you time once you start the argument. Counsel for the parties are present. Counsel for the petitioner prays for and is granted time till 27 February 2024 to seek instruction and file a rejoinder to the counter affidavit if any, if so advised.
If so, it's your
Pose this case under the heading for final disposal on 5th of March 2024. Parties to file short synopsis, list of dates and the judgments which they seek to rely upon much prior to the next date of hearing. Next.
Item 5, WPS 2396 of 2023.
Yes, petitioner. Yes.
Matter related to termination of para-teacher lordship. A inquiry has been set up by page number 18 lordship. It has been alleged that that attendant, so some student was
Where is the order of
as per the
where is the order of removal? Where is the order of removal?
inquiry has been set up lordship at page number 18.
So you face the inquiry.
By page number 18, inquiry has been set up.
Okay. So
And the report is at page number 19 lordship. She found innocent. By inquiry report at page number 19, she found innocent. This is the report submitted by Jharkhand officers.
page number 19. Can you read it that you have been found innocent? Read it.
पेज नंबर इसमें कार्य मुक्त किया गया है. अब पेज नंबर 18 का मुझे इसमें रिपोर्ट है. पेज नंबर 18 विद्यालय में कभी भी फर्जी उपस्थिति नहीं बनाई जाती है. ये रिपोर्ट है मेरे पेपर में.
No, where is it? Page number?
पेज 17 में रिपोर्ट है 18 में और टर्मिनेशन ऑर्डर है 19.
No, where is it? You read the report that you have been found innocent. Yes, read it, please.
पेज नंबर 19 में हमको टर्मिनेट करते हैं विदाउट अबाइडिंग बाय हिज ओन रिपोर्ट.
You
और
were
काउंटर
marking
में
the
बोल रहे हैं
you were marking the attendance of the absent candidates.
टीचर हैं, हम कभी भी काउंटर में बोलते हैं कभी भी किसी को टर्मिनेट कर सकते हैं अगर उसके कार्य से हम संतुष्ट नहीं होते। ये कार्य से संतुष्ट नहीं होने पर जांच करवाए, जांच में हम निर्दोष पाए गए। और कोई सीरियस एलिगेशन नहीं था, 4 बच्चे कम थे क्लास में, उसका एक्सप्लेनेशन दिया गया, एक्सप्लेनेशन से सब संतुष्ट हुए, रिपोर्ट भेजा गया।
This is an appealable order under the
Yes, yes. This is applicable before the director boards.
it is appealable before the director.
JPC.
It is appealable order before the director JEPC. You go and file your appeal.
My lord, but
You file your appeal before director JEPC.
and that forum is not available, lordship, only for
Everybody is filing and they are getting the orders.
position created, but the writ petition is
You
being
see-
entertained by this honorable court because of the forum is not functional.
Which forum is not functional? Director JEPC is absent.
Appellate forum.
Director JEPC is the appellate authority. Who is the appellate authority? Which is the appellate forum which is non-functional?
ये कहते हैं कि अपील इसमें प्रेफरेबल है,
हाँ.
तो
Director JEPC.
हाँ,
Director JEPC, you go and file an
ये
appeal.
पारा टीचर है
She is all in all members for the
और
project.
इनका
Sub Shiksha Abhiyan, she is the apex body.
this order has been passed without jurisdiction and in violation of natural justice.
No.
हमको कहीं ये मौका नहीं दिया सुनवाई का, in violation of natural justice है, इन्होंने हमको मौका दिया, मैंने रिप्लाई
You file your-
मेरे फेवर में रिप्लाई, जब फेवर में रिप्लाई था तो
Where is your reply? Where have you annexed your reply? Your reply is not on record. Where is it?
reply है annexer सोका photocopy written dated, हाँ annexer 3 है, page number 7.
You admit in your reply. You have admitted that these children were absent when the
And
inspection was
except
done.
can be seen minutes. Page 16.
Yes,
That is a reply.
he has admitted.
इतना सामाजिक 5 बच्चों को
5 बच्चे नहीं थे.
कारण ये सत्यापन के 2 बच्चे शौचालय गए थे, 3 बच्चे कॉफी पे
बाहर गया था, वो वापस
पढ़ाते
आ
हैं,
गया,
कुछ है नहीं, खाली वही है,
पाया गया।
सारा 12 पीछे
ये
आप अपना अपील में
ये फर्जी था, स्टूडेंट थे स्कूल में।
I'm sure that these children also must have been.
वो लोग किसी कारण
No,
से
no,
बाहर
you
गया
go and
था,
file your
वो
appeal.
भी- वो पेन लेने के लिए 4 बच्चों का, और जब ये इंक्वायरी सेटअप किए गए तो मेरे दावा को सही पाया गया।
You file your appeal. You file your appeal. There are all facts involved in this case. Director JEPC, no?
She is the all in all for the JPC members.
Jharkhand Education
Project Council.
Project Council. WPS number 2396 of 2023. Learned Counsel for the parties are present. The Learned Counsel for the respondents has submitted that the petitioner has efficacious alternative remedy of filing appeal before the director Jharkhand Education Project Council and disputed questions of facts are involved in the present case. In response, counsel for the petitioner has submitted that upon an inquiry, that an inquiry was set up in connection with absence of certain children at the time of midday meal. Midday meal के समय ना?
स्कूल से ही गैप थे,
Absence of certain children on the date of inspection, and a proper explanation was submitted. An inquiry report was also furnished in favor of the petitioner, but still the authority has recorded a finding that the attendance of absent students were marked in the attendance register which had a bearing in the amount involved in midday meal. The Learned Counsel has submitted that in spite of due inquiry, the impugned order has been passed and therefore it calls for interference under Article 226 of the Constitution. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court finds that there are disputed questions involved in the present case which cannot be adjudicated under legal jurisdiction. The petitioner has efficacious remedy before Director JPC, who may consider the grievance of the petitioner after
Hearing both the
scrutinizing the records and granting an opportunity of hearing to the petitioner. Accordingly, this writ petition is accordingly, this court is not inclined to grant the relief as prayed for in this writ petition. However, the petitioner may approach the Director JPC by filing an appeal within a period of 15 days from today. The appellate the said authority will pass a speaking order after considering the records and after granting an opportunity of hearing to the petitioner
as well as local authorities
as well as the concerned authority,
gratefulness.
and pass a reasoned order within a period of 6 weeks from the date of filing the appeal, and the appellate order be communicated to the petitioner through speed post.
In fact, those who are approaching, she is the director, is the science lady. She is very kind. She is always हमको कहती है कि छोटा मोटा में क्या ठीक है जी.
Item 6.
Grateful lordship.
Item 6 WPS 2433 of 2023.
This matter pertains to appointment in lieu of for promotion, wherein the case of the petitioner has been rejected, that the criminal case has been pending, Your Lordship. I'm praying for ad hoc appointment, ad hoc promotion, Your Lordship, till the final outcome of the criminal case.
You can't be given promotion subject to your result. If the criminal case was arising out of your official duty,
Indeed, Your Lordship.
If
But
it-
there's
under
one
which
catch.
section?
The provisions which are involved
420.
that I have annexed the FIR information. The final form is at page number.
Under PC Act.
CCA close.
You want promotion?
But the co-accused who are named in the FIR have been given the promotion, Your Ladyship. And in the
Wrongly
final
given.
form, Your Ladyship, the investigating officer.
No, we cannot appreciate the final form. The trial has begun.
No, not yet, Your Ladyship.
Your final form has been accepted.
No, Your Ladyship.
It has been found untrue.
Observation has been made that there is no evidence against the petitioner's, Your Ladyship.
Okay. So
And the
you go to the court, get the final form accepted. The
This,
final form will be accepted by the court and
This-
drop, and the criminal case will be dropped against you because there is no evidence against you.
the co-accused, Your Ladyship, they have been given promotion.
We are not concerned with that. We can't give promotion to.
That can be distinguished, Lordship. Both
May I
hasn't
just say,
argued that both are similar, they are not similar, Lordship. In both cases, the authority is different who provides promotion, who considers the promotion.
Authority may be different, but how do you give promotion to persons who have criminal cases? You can give promotion.
yes, there is a provision, Your Ladyship, in the
Even
circular
under-
of 2008. There is provision even in case of pendency of criminal cases. Cases for promotion may be considered subject to the outcome of the criminal case.
That will be kept in sealed covers.
Yes.
Sealed cover, but ad hoc promotion may be given
And
in case.
Show me that provision that during the pendency of criminal case under PC Act, they are bound to consider your promotion.
They are not bound. They have to take a decision whether the candidates can be given promotion or not. That is there. And
They have
but
taken a decision not to consider your promotion. That is why you have.
they
come.
have kept my their decision in the sealed cover.
They have
but my
kept it in
case-
sealed cover.
Lordship,
Yes, sir.
Rightly so.
My only point, Your Ladyship, is that the co-accused in the same FIR.
Madam, why don't you understand? If it is a case of no evidence, you go to the court. It will be accepted.
There have been cases in of our Honorable High Court wherein cases have been decided in this ground, Your Ladyship.
Sure.
Therefore, Your Ladyship.
That in spite of the sealed cover procedure, you are entitled to
That
promotion.
can be done, Your Ladyship.
Show me one judgment.
Yes. I've cited judgment at para 19 of page number 60.
Para 19.
Yes.
What is that judgment?
That is Purushottam Kumar Singh versus State of Jharkhand and others, wherein the case of the candidate was rejected on the ground that a criminal proceeding has been pending and the sanction of initiation of criminal proceeding has been granted. And in the case of State of Madhya Pradesh,
K.V. Janki Raman is talking about sealed cover procedure only.
yes, when sealed cover would be applicable. In this case, Your Ladyship, sealed cover procedure would not be applicable even, because if I may be permitted to bring on record the lower court's document, the judgments, Your Ladyship.
No, we will not enter into that. You say
Because-
that your criminal case is pending against you. Admitted?
Yes.
Yes. Now you tell us that in case where the criminal case is pending, in case of Janki Raman, that is a lead judgment.
Indeed.
Then also you are entitled to promotion. Where is the Janki Raman judgment?
Janki Raman is
Which paragraph are you referring that you are entitled for promotion? Tell us.
para 16 and 17 of the judgment, Your Ladyship.
What does it say? Read it, please.
On the first question was as to when, for the purpose of the sealed cover procedure, the disciplinary criminal proceedings can be said to have been commenced. The full bench of the tribunal has held that it is only when a charge memo in a disciplinary proceeding or charge sheet in a criminal prosecution is issued to the employee that it can be said that the departmental proceedings criminal prosecution is initiated against the employee. The sealed cover procedure is to be resorted to only after the charge memo charge sheet is issued. The pendency of the preliminary investigation prior to that stage will not be sufficient to enable the authorities to adopt the sealed cover procedure. We are in agreement with the tribunal on this point. The contention advanced by the learned counsel for the appellant authorities that when there are serious allegations and it takes time to collect necessary evidence to prepare and issue charge memo and charge sheet, it would not be in the interest of the purity of administration to reward the employee with a promotion, increment, etc. does not impress us. The acceptance of this contention would result in injustice to the employees in many cases. As has been the experience so far, the preliminary investigations take an inordinately a long time, and particularly when they are initiated at the instance of the
Has
interest.
the petitioner been put under suspension?
He's working, Your Ladyship. He has
That
not
is
been.
not coming the
And,
council.
no, that is
Whether
there in
he,
the appointed
he
affidavit.
was suspended or not. So far as
Where is your final form?
Final form is at annexure. Four, Your Ladyship, and it is starting from page number 40.
In PC case, it has become a case of no evidence.
Yes, Your Ladyship. And it has been specific
Page
observation.
number.
Page number 40. And
Sanction for prosecution has come? No.
No. And moreover, page number 59 is the concluding.
No, first let us see your final form.
Final form is
That
page,
no case is made out against
Yes,
you.
Your Ladyship.
Page
Page
number?
number 40 is the initial page.
40.
Yes. Annexion number 4. And the relevant portion is at page number 59, the concluding portion.
When was it submitted?
It was submitted in the year 2020, Your Ladyship. and the promotion matter was considered in the year 2023. Till that time, no initiation with regard to framing of charges was done, and it was stated in the
No, it is not framing of charges.
and no charge sheet. If I can read the lower court
No,
order.
no protest was filed by the informant.
They
This has been accepted by the learned court below.
With regard to, they have not accepted. The lower court has not accepted. The informant is not coming before the lower court. And time
Where
and
is that
again,
order sheet?
that order, if your ladyship may give a day time to me, I'll bring that on record. And it has been stated, no charge sheeted for warrant of evidence. For
Where
offence under
is it? Page number?
that your ladyship, I have got the certified copy.
Where is that page number?
That has not been.
Final form, page number 59. Page number 59, last paragraph. Last few lines would be relevant. Last 7 lines. 11 Shri Mahesh Ravidas, तत्कालीन कार्य अभियंता लोहरदगा एवं स्वयं सो के विरुद्ध साक्ष्य की कमी देखते हुए अंतिम प्रतिवेदन संख्या स्वयं सो दिनांक 16/1/2020 धारा स्वयं सो के अंतर्गत समर्पित करता हूँ एवं इस कांड का अनुसंधान बंद करता हूँ। इस कांड में प्राथमिक के नामदर्ज अभियुक्तों में सेवानिवृत्त एवं मृत अभियंताओं को छोड़कर शेष कार्यरत अभियंताओं के विरुद्ध विभागीय कार्रवाई हेतु उनके प्रशासनिक विभाग को प्रतिवेदन समर्पित किया जा रहा है के विरुद्ध साक्ष्य की कमी देखते हुए बंद किया जा रहा है।
Departmental proceeding initiated.
Nothing has been initiated. Just because of the pendency of this case, and the FIR was lodged in the year 2016 itself.
This is vigilance case number 61 of 2016.
Indeed, Your Lordship.
You have annexed a copy of the order sheet of the learned court below.
I have the copy of the certified copy. Your Lordship.
How do we see that?
If it can be kept tomorrow or day after tomorrow.
Where is it? The learned counsel for the petitioner submits that one vigilance case number 61 of 2016 was filed against the petitioner and other co-accused, and which was filed under the provisions of under various sections of Indian Penal Code and also Prevention of Corruption Act. However, after investigation, a final form was submitted to the learned court below on 21/1/2020, indicating that the charge that the allegation was proved against the retired persons and those who were dead. But so far as the current engineers are concerned, no material was found during investigation. However, a recommendation was made for the purposes of initiation of departmental proceedings. She submits that neither the petitioner has been put under suspension, nor the petitioner has been served with any charge memo in the departmental proceeding, nor the petitioner as on date stands charge sheeted, and therefore in view of the judgment passed by the Honorable Supreme Court in the case of Union of India versus K.V. Janki Raman and others, paragraph 16, the case of promotion of the petitioner could not have been put under sealed cover. She has produced a photocopy of the certified copy of the entire proceedings before the learned court below, indicating that on 21/1/2020, notice was when final form was submitted before the before the concerned court, notice was issued to the informant fixing the date as 11/2/2020. And till date, the informant has not appeared before the court, but as of now, neither any protest petition has been filed nor the final form has been accepted, but the fact remains that the petitioner cannot be said to be an accused for the purposes of accused in a criminal case for the purposes of consideration of his promotion, and therefore the case of the petitioner could not have been put under sealed cover. Pehle to you just take care of this.
Moreover, co-accused relationship, they have been granted promotion.
The learned counsel has submitted that the co-accused in the same criminal case have been granted promotion and their matter has not been kept in sealed cover. And such action with regard to the co-accused is in consonance with the judgment passed by the Honorable Supreme Court in the case of Janaki Raman. But the petitioner has been discriminated. Counsel for the respondents is directed to seek instructions and file a counter affidavit.
Counter is already there, Lordship.
File a supplementary counter affidavit with regard to the submissions which are of the petitioner which has been recorded in this order. The supplementary counter affidavit should be filed by, how much time do you need?
3 weeks.
3 weeks. 3 weeks. Okay. As per the order sheet produced by the petitioner, the next date before the learned court in the criminal case is on 6/4/2023. Post this case on 8th of April. In the meantime, the supplementary counter affidavit should be filed.
Item 7, WPS 2527 of 2023.
Leadership, I crave for an indulgence in this matter. We were directed to file a counter affidavit. Only 1 week time they can be given. It is in the process.
Counsel for the parties are present. At the request of the counsel for the respondents, post this case on 28th of February 2024. Let the counter affidavit be filed by 27th.
Congratulations.
Item 8, WPS 2543 of 2023.
Yes.
Lordship, we were directed to file written notes of argument.
Filed it?
Yes, Lordship. Our written notes of argument.
I have already filed mine.
Counsel for the petitioner seeks adjournment next week. What is this written note of argument?
All judgment has also been included here.
I hope that there is nothing which is beyond the record.
Yes, Lord.
Everything is from the record.
Except the judgment.
Judgments need not be form a part
Facts
of the record.
and facts are from the pleading and everything is on record.
And the documents are also from the record?
Yes, Lord.
Next week.
Item 9, WPS 2749 of 2023. Long item 10.
एक चीज और लिखिएगा written submissions have been filed by the parties on the next week for final disposal. Yes.
As we are all aspiring to become graduate trained teachers in physical
This
education.
21 of 2016 is over.
This the advertisement. But if the posts are vacant or my candidature was wrongly disqualified,
There is a direction of the Supreme Court that no further, nothing will be done by the High Court in contempt case in Soni Kumar.
otherwise also this has to be decided, the issue has to be decided. Whether I'm entitled to be appointed as a teacher of physical education if I have BPET and BPLET. The lordships have decided one case against us. But I see that many of the submissions which I seek today have not been raised or answered.
Sanjeev Kumar.
There were two judges, one Chongoto.
Yes. So you want, if there is a contrary judgment, and then you want that this should be referred to a larger bench.
If that is so much, if I can satisfy your lordships that many issues have, or one of the issues which have not been raised, your lordships have not decided. I don't see a reason for your lordship not to.
No. You see, when it comes to educational qualification
Correct.
and the candidature of a particular group of candidates altogether, then under such circumstances, one issue raised, not raised, that will not give a different judgment.
The only issue
Right.
is not.
Then I will have to refer it to division bench for consideration. But you tell us that what is it that has not been considered?
Because here what I find, I have in my writ petition brought on record certain documents which says that the qualification which I have, that is BPET, is equivalent to graduation, and in a case of physical
Who has
education.
given you the equivalence?
Government of India, 1970 onwards. This is the Government of India notification. And NCT regulations also show. I'll show. Those things are not brought to your lordship. I was to say that a person, a teacher of physical education who has a bachelor, not a diploma in physical, I have a graduation in physical education, will not be entitled to qualify because he doesn't have BA, BCom, BSc. That would be, it seems a bit.
You see, now they have taken into consideration that computer science, BSc in computer, and then some MBA degree also.
BBA. I have judgments to that effect where the coordinate benches have actually considered a BBA degree equivalent to a arts management degree or BTech equivalent to a science BSc. So, but I'm saying in a physical education subject, if I have a graduation in physical education along with a diploma, and then to say that I'm not qualified, then the courts will that. And therefore they are saying, if lordship allows me to place, I'll just
Let us
show.
see the requirement as per the advertisement. We go
BSc.
as per the advertisement.
Advertisement, but it has to
You are not challenging the advertisement as
I need not, but I am saying the advertisement has to be considered, construed in the correct perspective. What it says is page 33. Page 33, item number 7.
After 31, I have 35.
Page 33 is not there?
This at other place. Anyways, page 33, item number 7.
शारीरिक शिक्षा राज्य सरकार अथवा केंद्र सरकार द्वारा मान्यता प्राप्त संस्थान से कला, विज्ञान अथवा वाणिज्य में न्यूनतम 45% अंकों के साथ स्नातक डिग्री तथा मान्यता प्राप्त शारीरिक शिक्षा डिग्री. This is it. So their simple understanding is BSc, BA, BCom with 45% and a regular degree in physical education from a regular. I have bachelor's in physical education, which is graduation in physical education. They are not considering. Now let us not kindly come to page 61.
basically.
861, this is a 1970 very old letter, but it starts here. Your Lord, there is an underlined portion if your Lordship can see, and these BP degree holders,
61.
14 December 1970. Then your Lordship will see the underlined portion, and these BP degree holders should not be required to possess an additional BA.
You read it fully, please.
Sorry, miss?
Read it full text.
Very good. I am directed to invite your attention to the marginally quoted circular letters from this ministry on the subject mentioned above, wherein attention to of the state governments, universities, and other concerned authorities was invited to the decision of the number 1, 2, 3 members. University Grants Commission that Bachelors of Physical Education degrees holders from Lakshmibai National College of Physical Education, Gwalior, affiliated to Jivaji University, be treated at par with persons holding postgraduate diploma in physical education for appointment of as director of physical education or physical education teachers in colleges and universities. This decision of the UGC implies that BP degree holders from Lakshmibai National College of Physical Education should be treated at par with those holding BA, BSc, BCom degree plus a diploma in physical education, and these BP degree holders should not be required to possess an additional BA, BSc, BCom degree for the purpose of employment as directors of physical education or on similar other posts.
So you are from Lakshmibai
No,
National?
no, I am not. Sir. This is just I am not.
This
from.
is only for Lakshmibai.
I am just now kindly come to notes page.
So one thing more, Lordship permit, my Lord. So far, 1993 Act has come along, NCT Act has come along, 1993, and there are several things have been changed.
They are already in trouble. Let them complete.
No,
Yes.
I am coming to their affidavit only. My learned friends.
No,
affidavit.
you don't go by their affidavit.
No, they
you
have
just tell us.
Yes.
You forget. You just tell us that from where do I get
Yes.
that your graduation in physical education is equivalent to BA in science, in arts, science, and commerce.
I am only saying, Lords, that if I go by the NCET requirements and what is the regulation which all schools are binding, they say when a teacher for a primary physical education is to be appointed, he must have a diploma and degree in physical education. That is important. So the Jharkhand government is acting contrary to this. Kindly take their affidavit.
Then you have not challenged the
I am saying that-
advertisement. That is not under challenge.
But the graduation, what they are confusing is that they are not understanding. I have a graduation. BPED is a graduation degree, 3-year graduation
You
degree.
see, read the advertisement as it is. You don't need to read anything
But
into
if it is reading gives an absurd result.
It is not an absurd result.
It is. What would be the absurdity is that a physical education degree or graduation is not being preferred to a BCom degree. You want a specialized teacher of a specialized subject to say that for the teacher of accounts, I will not recognize BCom. I will want BA and BSc, but not this. That is
So
what.
therefore, this particular clause ought to have been challenged by.
It has to be read down. Not it has to be. This has to be read. Your Lordship will not read. It's a hyper-technical
When
approach.
there is absolutely no ambiguity in the language used, there is no question of reading down.
The ambiguity, it's the intent. It's the intent. What does the law?
I don't see any other intent can be read into it.
Your Lordship, if it is not read, therefore it leads to absurdity.
So therefore, you should have challenged it.
If I would have challenged it as ultra.
If you want this issue to be decided for
Yes.
all times,
Yes.
you challenge it. We will decide it.
Very
But if you don't
I have
challenge
understood.
it,
Let us
we will
overcome
not.
this technical. Your Lordship is right that there can be an
There
objection.
has to be a clarity on this, and if it is, you see, we can understand. A teacher being appointed for physical education should be an expert in physical
Correct.
education.
I have understood. So, okay, Lordship, can you give me 10 days time?
I will give you time, but I understand. You just tell us. Please. Let me just talk to AICT. You are there for AICT. Yes, you just tell us. When you appoint teachers for physical education, you want the students to be physically fit, right? There are so many competitions where physical education and physical fitness is one of the prime criteria, isn't it?
Yes,
So you want teachers who have graduated in physical education, or you want teachers who have graduated in science, maths and arts?
As per the advertisement.
No, you forget about the advertisement. They will challenge it. We'll see.
Graduation with a degree for physical education.
No. You see, you have a specialized degree on graduation in physical education, right? And then you have a diploma also additionally in physical education. When you are recruiting a teacher for physical education, then under such circumstances, how do you prefer a teacher who has studied arts, science and commerce in preference to a person who has done his graduation in physical education?
It's not preference, it's requirement of dual degree because the physical education is the specialized thing. So first the graduation with the physical education degree.
They have a graduation in physical education, they have a diploma in physical education, but they are excluded because of your clause.
The state has to answer this because that the parity
This
with the
answer
degree,
will
it has
come
to be.
from the
It has to-
state. Yes,
it has
what
to
were
be
you
decided
saying?
by state, the
What were
parity
you
of the
saying,
degree.
Mr. KK?
Counter has not had, but your lordship kindly consider. But they have participated in the selection.
You forget about, you just say they want in principle this issue to be decided. Because this is something which will come again.
My objection is, can the petitioner be allowed to raise objection, Lord, after participating regarding the provision made in the advertisement itself? Your lordship,
That I will
consider
satisfy.
this aspect of the matter.
No, it is for all times to come. They want it to be decided for all, and at least you should know that this is a problem in the advertisement, such that you take care in future also. This kind of criteria where you are recruiting teacher for physical education and you do not recognize that they are graduates in physical education.
Describing,
You forget one thing. As a citizen, you just tell us. Does it sound to reasons? There is a judgment also on this, Mr. Sinha. I have read it. There is a judgment of Supreme, very recent judgment.
Yes, I asked Mr. just to my research. What they are confusing is like BA, B.Ed hota hai, Bachelor's of Education is 1 year degree, B.Ed is necessary. For physical education is BPED, that is 1 year degree. But I am a 3-year graduation in physical education plus BPED. So I have 2 degrees which they are missing. Like for ordinary I want BA and B.Ed. B.Ed is mandatory as per NCT. For physical education what is mandatory is BPED, that is the 1 year degree of specialized. But I am graduation of 3 years plus 1 year 4 years. They say no, you are out. Anyway, but your lordship is correct. I will try and not.
You say you are by this method, by this kind of criteria, you are straight away, discouraging people to go and have specialized degree in this physical education. Physical education is being taught as a subject in graduation, isn't it?
Yes, madam.
Do you say that the graduation in physical degree, physical education is not equivalent to other graduation?
Well, this is the main issue, my lord. It is apparent from the guideline issued by the NCT and also, my lord, that BA, BSc must thereafter BPED. It is not necessary. It is not that BPED only. First of all,
does it exclude BPED? NCT, does it exclude BPED?
Yes, I have counter my lord this.
What stuff has been used in the advertisement?
I have held counter also, my lord, contending that this aspect, my lord. If lordship see, my lord, this is the contention of the NCT, my lord, in respect of different type of education, senior, secondary, and intermediate education. My lord, kindly page 8 of my counter, my lord. My counter 8 will be seen, my lord, and thereafter.
Grade 8. Bachelor of Physical Education or Bachelor of Physical Education
BPE
or Bachelor of Science in Health and Physical Education and degree in sports with at least 55% in National Council for Teachers Training. What is it do you want to say?
No, they are with me. They are supporting my case. Kindly come to the regulation page 16. My learned friend probably has misread it, minutes. They are kindly come to along with page 16 minutes of that same affidavit I wanted your lordships to see. Second schedule, page 16. Let us come to page 16.
Yes, yes.
Now, second schedule. National Council for Teachers Education determination of minimum qualification for persons to be recruited as physical education teachers in primary, upper, secondary regulations. This is the regulation specific. For primary and upper primary school minutes, they want a class 12 pass, class 12 pass, class and last is certificate diploma in physical education of duration of not less than 2 years from any NCT recognized institution. Very well, Manoj. This is just the BPED. Now, secondary high school. Bachelor's degree with physical education as an elective subject. Bachelor's degree with physical education as an elective subject marks with so and so. And higher secondary, you will see again graduate in physical education with 40 marks. So they themselves are recognizing this is against the NCT regulations. This is also my case that the state government is acting contrary to NCT regulations. Because what I am saying, the NCT is also saying that yes, if you have a BPED, it is as good as graduation. You don't require BA, BSc. And the last one says senior secondary, Bachelor of Physical Education or Bachelor of Physical Education or Bachelor of Science in Health and Physical Education and degree in sports with at least.
And
Oh no, वो तो एक साथ है. Or
You
Bachelor
just
of
tell us this is not the only field, right? There are other specialized fields, like suppose vocal music or maybe guitar. You have graduation in all these subjects from universities, right? Somebody is having a MA degree in a particular subject but graduation in this specialized subject. Whenever there is a specialized subject and you want a teacher in that specialized subject, how do you exclude graduates of that particular specialized subject and include BA, BSc and BCom? How do you do this? Suppose there is a BTech student.
yes, I understand.
You will exclude.
No, I'm not.
Will he be treated as BSc?
Your Lordship, next case is that only. In the next case, item number 10, the graduation is, the petitioner is BTech and because he is BTech and thereafter diploma in physical education.
sir.
So that is the case.
I am
So
relying upon my lord.
he
I am
is
relying on
excluded.
the basis of the notification which was.
This notification is ex officio in their favor.
That is there, my lord. That is our document.
That is there. You should be a neutral person. All writ petitions are not to be opposed. You are the most authentic person who can actually respond to all this.
That regulation. That's
Are you governed by AICT regulations?
No,
State?
NCT, National Council.
NCT regulations, are you governed by it?
Yes,
State?
ma'am. Under RT they have to.
They have to. Where is the
everyone.
state, Mr. KK Singh? What were you saying? Yes, you tell us now. How do you exclude?
My lords, a counter affidavit has been filed by the state. My lords, in the
You are for the state?
My lords. My lords, in the said counter affidavit, we have mentioned that as per government secondary school rule 9(1), my lords, may kindly have annexure of the counter affidavit, my lords. My lords, if I may permitted to read. सरकारी माध्यमिक विद्यालयों में इस नियमावली के नियम
The entire system and the thought process requires to be overhauled. You only know BA, BSc and BCom. You don't know any third degree.
My lords, in that we have mentioned 5 years. If he has 5 years of experience, my lords, may
Experience as?
My lords, 5 years of graduation, my lords. 5 years. In BCom, BA, if I may permitted to read, my lord. सूचना निर्देशक माध्यमिक शिक्षा द्वारा जिलावर जिला शिक्षक पदाधिकारी से प्राप्त हुए कर्मचारी चयन आयोग अथवा राज्य सरकार द्वारा नियुक्त सक्षम पदाधिकारी के रूप में प्रधारित को भेजी जाएगी। चिन्हित रिक्तियों में 25% पर सरकारी प्रारंभिक विद्यालयों को निर्धारित अर्हता प्राप्त 5 वर्षों के अनुभव रखने वाले शिक्षकों द्वारा तथा 75% सीधी नियुक्ति द्वारा भेजे जाएंगे, परंतु यह कि प्रारंभिक विद्यालयों की नियुक्ति अर्हता प्राप्त शिक्षकों हेतु आरक्षित पदों पर योग्य शिक्षक प्राप्त संख्या भी नहीं पाई जाएगी। राज्य सरकार या केंद्र सरकार या विश्वविद्यालय अनुदान आयोग द्वारा मान्यता प्राप्त संस्था से संबंधित विषय जिसमें नियुक्ति होनी है में न्यूनतम 45% अंकों के साथ स्नातक डिग्री अनिवार्य होगी, परंतु अनुसूचित जाति एवं
आप जो ये पढ़ रहे हैं घर पे पढ़े?
मनोज,
इसका क्या रेलेवेंस?
मनोज, ग्रेजुएशन डिग्री इन बीकॉम।
आप अभी आए नहीं लगता बाहर से बैठे थे यहाँ। We want to know हिंदी में समझा, right? There is one BA, BSc, BCom, and there is a 4th degree which is a graduation in physical education. You are recruiting students, you are recruiting teachers for physical education. But you say that you will take BA, BSc and BCom and not take the teachers who have, the candidates who have graduation in physical education. Explain. कल को कोई मतलब I just I'm absolutely clueless how this kind of.
According to advertisement, two qualification is required. One is BA, BSc and BCom,
Yes.
and another is physical.
So I want to know, how do you exclude this?
I'm not excluding because two qualification has been prescribed and both qualification is essential.
That's right. Both the qualifications are essential. We have decided this only.
Lots.
But how do you justify exclusion of BPED, graduation in physical education, for recruitment of teacher of physical education?
I'll file that application.
You file your application?
I guess, I think without wasting any further time.
Without that,
I'll make out an application.
So far, Sangeet is concerned,
Sangeet, you forget about Sangeet. You talk about this physical education.
Item number 10, I'm relying on judgment of the division bench.
That is covered.
It's the subject of home science for the same advertisement. The home science subject was subsidiary. The petitioner got qualified. Then the petitioner came before this court, and after the division bench has said that as the requirement was for graduation in that subject, so home science as a subsidiary will not be considered.
Okay.
So
and now,
in my case, in item number 10, it's a graduation in, he is an engineering graduate, technical graduate, and thereafter the diploma in physical education. So that case is case number 9 and syllabus.
So he cannot be considered as BSc?
No, not BSc. Because it's BTech degree, so it will be not considered.
I have a judgment of a single judge holding otherwise. But what I'll do is, anyways, I'll challenge the advertisement. Then let me challenge the advertisement, and because I don't know what the person who is engineering graduate becomes subservient to a science.
You see, if you have a science stream, you can have physics, chemistry, maths. Right? The same subjects are being taught in engineering also. Best of the two students amongst the science stream having PCM go for this engineering degree, and you disqualify them. Now, you see, now the time has changed. You have multidisciplinary teachers, multidisciplinary approach. You may have an advocate going in teaching line in schools. You can have engineers going in teaching line in schools. You can have many things. You can have doctors coming in different. There are interdisciplinary flow with regard to the candidate seeking recruitment. You will discard engineer. Does it sound good to you?
As an officer of the court, I have to say something else, but as a counsel for my client, I have to stick on the instructions.
But you see, we will not give you relief which is beyond what is.
Rule is concerned.
The point is, sorry, time and again this issue will arise. All these students or whatever they have studied, for all times to come, they will be shot. So they must know. Either I get it or don't get it, they'll pursue us.
That's right.
So only a short date or optional final application and let this issue
and take care of everything.
Everything, I will. So
you take care of NCT.
I will.
You take care of this advertisement.
Because I'll draft an application properly with an amended entry so that there is no problem. Let it come up to weeks.
The learned counsel for the parties are present. You are there in the second case also?
Yes.
The learned counsel for the petitioner has submitted that. So far as induction to the post of teacher on physical education is concerned, the respondents have prescribed the required qualification as BA, BSc, BCom, but graduation in physical education has been left out. The learned counsel submits that the same appears to be arbitrary, but the clause of the advertisement is not under challenge, and therefore he seeks adjournment to file an appropriate petition. He submits that the clarity in this regard is necessary such that the petitioners and others have others plan their career
Yes.
appropriately. So far as WPS number, where is the other one?
उसमें भी same. Do that also same. Here there is
WPS number 4702 of 23 is concerned. In this case, the petitioner is an engineer having a BPED degree.
BTech plus BPED.
Engineer having a BPED degree but has been disqualified on the ground that he does not hold BA, BSc and BCom degree. The council submits that this also does not sound to reasons in as much as the candidates of engineering degree essentially study science. That is physics, chemistry and maths. When should I post it?
That is coming from the rule itself.
We will see that. There has to be a clarity. You can't have it like this.
First case.
First case.
Serial number 9.
What do you want?
Rule has been filed.
Let them file their application.
They have to challenge the rule.
Whatever, they will examine everything. I have told them to file it.
That has been mentioned.
And maybe that this matter may have to be referred to a division bench. Once the rules are challenged, I will refer it to the division bench. When do you want? Post after 2 weeks at the date.
Yes.
Item 11, WPS 2750 of 2023.
Yes, petitioner. What is it?
Plus this relates to promotion to grade 4 minutes of a teacher minutes the petitioner. The case is that the petitioner belongs to reserve category, scheduled caste. Now the vacancy as far as grade 4 where I am seeking promotion is concerned, there were only 21 vacancies. My position was next to it, 22. They say that since vacancy was only 21, your position was 22, so you are not entitled for consideration. My case is that though I belong to reserve category, but I have never been appointed under this category. I have not taken any benefit thereof ever. So I am a general category, that is called unreserved, though belonging to that category. And the persons who are in unreserved category, below me, many persons have been considered and promoted to grade 4.
Below you?
Yes.
Why have you been left out? Because you are SC.
Yes, this is the only reason.
So where do you get this?
हाँ यही whole case यही है. तो respondent का क्या कहना है? उस चीज का जवाब ही नहीं दें. Core issue है फिर that I belong to reserved category, but since I have never taken any benefit, so unreserved I am. Once you are considering the persons below me, I have indefeasible right to be considered. And I have annexed notes when they file the counter affidavit. There is a broad guideline by the government of India also. Because it is followed.
Where is that? Is there any impugned order?
No.
Then?
Impugned order नहीं.
तो फिर?
तो हमारा कंसिडरेशन का है नहीं कर सकते कंसिडरेशन देना है
ना कंसिडर करके रिजेक्ट कर दिए हैं क्या?
He's not been given because below he was appointed. Below
they say you are not within zone of consideration.
Not within the zone of consideration.
How is he not?
Page number 21 of their petition notes.
20.
Page number 21.
Yes, 21.
Serial number 146 minutes.
146.
On the 7th column, minutes from the top. Category. The appointment is under scheduled caste.
No, this is not the thing.
And this is the basis. Because
it is one thing to say that a person belongs to scheduled caste.
Yes,
it is another thing to say that he was appointed against a scheduled caste vacancy. Both are not one and the same thing. This is what he is saying. He says that he was never appointed, he did not seek any reservation, and he was appointed like any other category. Is it mandatory for a scheduled caste candidate to seek reservation? No. Is it mandatory? He can apply in the general category. So, this is what you need to consider. No, we will ask you to consider this only. Right?
And we can dispose of it.
You can dispose of it. Is that okay? Who will consider it?
No, the DSC.
DSC will not consider this.
The DC.
The
Response
director,
3, the chairman come managing.
the director, primary education will consider it. He will
ये-
seek
ये-
all
ये
information.
प्राइमरी स्कूल का है ना, एक मिनट, प्राइमरी स्कूल का है ना,
I have
तो
to-
डिप्टी
respondent number
कमिश्नर,
2.
हाँ, डिप्टी कमिश्नर इज द चेयरमैन ऑफ द डिस्ट्रिक्ट एजुकेशन एस्टेब्लिशमेंट कमिटी,
Okay. They
डायरेक्टर
would be
करता है
the
हाई स्कूल वाला.
they would be the best person.
3, yes,
Respondent number 3.
yes.
The learned counsel for the parties are present. District petition has been filed for the following relief. The learned counsel for the petitioner submits that though the petitioner belongs to scheduled caste category, but at the time of appointment he never claimed reservation and was never appointed against any scheduled caste vacancy. And therefore, for all purposes, the petitioner is required to be treated as a general category candidate. The learned counsel further submits that the case of promotion of the petitioner is not being considered only on the ground that the petitioner belongs to scheduled caste category, and many candidates below the gradation list who belong to general category have been granted the promotion. The learned counsel for the respondents, by referring to the writ petition itself, has referred to Annexure 5 at page number 21 to submit that against the name of the petitioner, it has been mentioned that he belongs to scheduled caste category. However, he submits that if the case of the petitioner is that he was never appointed against any reserved category, then his case can be considered by the district establishment committee, and no adverse order regarding consideration of the case of the petitioner has been placed on record. No rejection order?
You minors may refer this circular which I have annexed.
I will not refer anything. This is what you have submitted, this is what I have recorded. This is at your risk.
No, my submission,
I am sure that your submissions are correct.
That submission factually
We take
correct.
your submissions as correct always.
Factually is correct.
That's it.
But circular says that if a person is appointed without taking any benefit of reservation, though he belongs to reserved category, then he has to be treated as such. And on this ground you cannot reject. That is the circular. Which I have
They will
annexed.
consider whatever the circulars are.
As your lordship.
The learned counsel for the, after hearing the learned counsel for the parties and considering the nature of dispute as argued by the learned counsel for the petitioner, and the fact that the claim of promotion of the petitioner and the fact that no adverse order against the petitioner has been placed on record by either parties considering or rejecting the claim of the petitioner for promotion, this court is of the considered view that the matter is required to be placed before the District Education Establishment Committee for the purposes of consideration of the case of promotion of the petitioner in accordance with the applicable rules, regulations, guidelines, and upon verifying the records of the petitioner. Accordingly, this writ petition is disposed of, enabling the petitioner to approach the respondent number 3 by filing a representation, detailed representation with supporting documents and a copy of the writ records within a period of 4 weeks from today. Upon filing of such representation, the respondent number 3 shall consider the grievance of the petitioner and pass an appropriate reasoned order after granting an opportunity of hearing to the petitioner within a period of 4 weeks from the date of representation.
But this much may be clarified that if I belong to general category, the scheduled caste category, but if I have not
You
taken
see,
benefit,
if there
on
is,
this ground they may not
if
reject.
there is any circular which is standing against you,
No.
then you have to challenge that circular.
No, there is
Otherwise, there is, I have recorded your
circular is in
submission.
my
That
favor.
will be bypassing the entire circular.
नहीं circular is in my favor. हम एक मिनट के लिए दिखा देते हैं. This much may be
आप अपना
clarified.
सब-
Otherwise
I
तो
will-
simply तो counter में कही दिए कि हम नहीं
No,
देंगे.
we want an order, speaking order on whatever circular you place, and then only we will see that what relief can be granted to you. You are just
इनका जो
seeking a
काउंटर है ना,
mandamus.
ये पूरा काउंटर में क्या कहते हैं
Their
कि हम
counter
आपको
is
नहीं
not the
देंगे,
impugned
हम
order.
रिजर्व में आपको नहीं ट्रीट करें. तो
Their
this much if
counter-
clarification is no, I will go, they will reject it.
Their counter is not the impugned order. So therefore, whatever you are saying, that will be considered. If there is any circular which is standing in your way,
In my submission only, my loss may record this annexure, this circular. In my submission that I have
Which
referred to this circular is not annexed with my rejoinder. Two circulars, 11 July 2002 and notes 10th August 2010, which says that if I have not taken any benefit, then I have to be treated.
this is 11 July 2002.
Yes.
And
And 10th August 2010.
this is of Government of India.
Yes, Government.
That circular is applicable upon them.
Government of India circular do not in
Exactly,
all
that is
our
a-
For SC, ST.
brace, broad guidelines are there.
If we have adopted,
Just,
the state
just,
of Jharkhand has adopted.
just एक minute, notes kindly allow me to read. Notes, the undersigned is directed. I am placing notes 11 July 2002. The undersigned is directed to say that this department has receiving references from various ministries, etc., regarding adjustment of SC/ST candidates promoted on their own merit in the reservation roster introduced by so and so dated so and so. While it is clear from OM dated so and so that SC/ST OBC candidates appointed by direct recruitment on their own merit and not owing to reservation will be adjusted against unreserved points of the reservation roster. Doubts have been raised.
It is there.
Yes, so they will consider this circular.
They will consider everything.
Reject
All the
कर देगा
circular.
माइनस.
No, इतना ज़्यादा नहीं.
वो खाली हमारा
Please.
सबमिशन में सर्कुलर दिखा दिया जाए.
The learned
I have made
counsel
this
for the
submission.
petitioner has referred to two circulars annexed with the rejoinder to the counter affidavit to submit that a scheduled caste or scheduled tribe candidate who has been selected on his own merit has to be considered as a general category. And merely because he belongs to one or the other category, no disability can be assigned to such candidate in the matter of grant of promotion. That's it. बाकी वही order है. Reason order आपको मिल जाएगा, आप अपना कर लीजिए. The state petition is accordingly disposed of.
Item 12, LPS 2767 of 2023.
Yes, petitioner.
Petitioner is seeking a direction of respondent to consider his seniority with effect from 25/7/2012 instead of 25/2016.
25
7/2012
instead of
25/2016.
20
हाँ 20/5
2016.
Yes.
Have you attained superannuation?
No, Your Lordship.
Okay,
I
you are
am
still in
still
service.
working, Your Lordship. I was appointed pursuant to advertisement of 2011.
It is financial upgradation or it's a promotion?
No, it's the financial implication is here
No,
because
financial implication
Yes,
has
yes.
to be there with.
Yes, Your
Is it a financial upgradation or it's a promotion?
No, it's just promotion, Your Lordship. My seniority will be counted from 12 instead of 16. And why I have come approach this court at this stage is the reason that in 2023 one advertisement has been issued by the Jharkhand Public Service Commission, where is one of the criteria for being appointed as directly on the post of principal of the school is 8 years have experience of as teacher. And because of this appointment in 2016 due to the litigation up to the apex court, I am disqualified by 6 months. If it was of if my initial appointment was given
So
in
this particular
Yes.
order which has been passed,
Yes,
giving you the impact from 25/2016, it's an order of appointment. Or it's
yes,
a-
Your Lordship. Annexure 6 is there. It is proper appointment, Your Lordship, pursuant to the Direction of the Honorable Court.
If there is a direction of the Honorable Court, then
Yes.
the Honorable Court must have indicated that you will get the benefit from a retrospective date.
For that, Your Lordship, I will refer Annexure 3 at page 22, the division bench order.
Where is your appointment?
Annexure 6, Your Lordship,
Page number?
at page 30.
This is pursuant to various orders?
Yes, Your Lordship.
Is there any order that you will be given with a particular cutoff date?
No, cutoff date is not mentioned, Your Lordship, but why it is so, Your Lordship?
How are you seeking from 25/7 to
Yes, Your Lordship, because that is the date when all other candidates pursuant to the advertisement of 11 have been given appointment. Initially, my certificate was, I could not produce the B.Ed certificate in time, for which I preferred writ petition, which was dismissed. Subsequently, I preferred LPA, which was allowed in my favor, with observation that my candidature should be considered and my writ petition was allowed. My writ petition, I preferred writ petition in 2012 only, Your Lordship. So, since the LPA was allowed and writ petition was also allowed at page 25, the operative part, Your Lordship. May I read?
You are seeking appointment in the same selection process?
Yes, yes. I am at present. I am working, Your Lordship. But due to this,
so they want experience.
Yes, Your Lordship. Experience
Then
of 8 years.
how do you get experience of additional 4 years when you have not worked?
Yes, Your Lordship. Yes, but let me.
It is one thing to say that you were working and subsequently some relief was granted to you. It
No.
is another thing to say that you got appointment by virtue of the orders of the court.
Yes.
And you joined on 25/2016.
Yes.
Right?
Yes, Your Lordship.
But how do we declare that you have 4 years additional experience?
Yes, Your Lordship. If Your Lordship permits me to read, because first point in support of that, Your Lordship, that I want till the apex court, Your Lordship, consider wherein the petitioner was not considered at any point that he was at fault. So litigation pursuant to the Honorable Supreme Court, they withdraw it with liberty to file civil review before the division bench of this court. So they prolonged and they delayed my
No, that is
appointment.
a separate thing.
Yes,
How do we give you experience of 4 years?
yes, also if my writ petition was allowed pursuant to the order of LPA, in the year 2012 itself, Your Lordship, if this appointment was to be given to me, was legally, since the other candidates were given appointments, as I won the order was in my favor, but due to this litigation on the part of the respondents, I was dragged for further 4 years till 2016.
You are not answering my question.
Yes,
not answering my question means that you don't have an answer. I just want to know, how do we give you experience of 4 years for which you did never work? Tell us. Because that is the requirement, because of which you are agreeing.
Yes, sir. For
The
that,
experience, the
yes, sir.
teaching experience which you never experienced, which
Yes,
you
sir.
never did, how do we give you experience of 4 years?
which I was not allowed by the respondents
Yes.
to give.
Yes.
But Your Lordship, I have one order of the coordinate bench, but I could not bring it out record today. Let it be tomorrow, Your Lordship. I will supply it, Your Lordship, exactly on this point. On this point only.
We'll file counter in this thing.
Last time it
But
was
there
the
is so
direction.
in filing counter. He is not able to answer the prima facie question. I'm just asking him that how do I give him experience of 4 years? He is not able to understand. He is able to understand, but he is not able to respond. Now he says that there is an order of coordinate bench.
Yes, Your Lordship.
Let us
I will definitely.
Does it say that you will become?
In that case, you say initial appointment was shifted by the government because of similar situation of litigation, Your Lordship.
That's right. That
Yes.
is okay.
Yes, Your Lordship.
But this will not entitle you to have experience of 4 years.
I will try to.
So
see
you
this
will
point.
not be qualified for taking part in the selection process, because what is required is the experience of 4 years, 8 years, whatever.
Your Lordship, just for sake of argument, Your Lordship, leaving away, because this is one of the.
I'm putting it tomorrow, get that order. Right? It will be just notional, you will not get anything at best, isn't it?
Yes, Your Lordship. You will.
You are seeking a mandamus or you
Yeah,
are
mandamus.
seeking
Mandamus.
You bring that order and then we'll see what order we are going to pass.
At 2:15 bench.
2:15 bench. Yes. Chal.
Just after one case, one matter is there. It will be posted on any sorted date. Today 15, it is 30. Subject to convenience of.
You see, I'm a very slow court. I take my own time.
Matters.
You have to
It
wait
consumes
23 matters.
I was only praying next week if possible.
Your case was taken up, you were not there.
Oh, that matter, that has been. I was on next-
so when your case is taken up, you are not here. When your case is below in the board, you want the matter.
That I'm sorry for that. It was another matter.
No problem.
And just after one case,
You have
I was
to
praying-
wait, you see, we can't.
Yes, I'm only praying next week any date subject. I'm not praying for this week.
So we will give our date accordingly.
The next bit is serial number 13, my lord. Earlier there were 2 times the directions were given to file counter affidavit, my lord. On the last occasion, by way of last intelligence, it was given, my lord.
In this case, my lords, we have received the instruction, it was not up to the mark, my lords. So, my lords, we send it back, my lords, for the fresh instruction, my lords. Within 2 days, my lords, it will come, my lords.
Right?